Good evening. I call to order this special meeting of the Governing Board, Scottsdale Unified School District number 48, and executive session. Today is Thursday, January 5th, 2023. It is 6 p.m. Happy New Year to everybody. Before we get started, I'd like to acknowledge and welcome our new Governing Board members, Carney and Werner, and offer our support to help them continue with our success and path towards excellence. Vice President Dr. Hartwells, can you please lead us in the Pledge of Allegiance?
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible,
with liberty and justice for all. Thank you. And we will start with a roll call vote from my far right.
Karen Warner. Amy Carney.
Zach Lindsay.
Libby Hartwells.
And I'm Julie Sanowski. Do any of the Governing Board members have any requests for changes or amendments to this agenda? Seeing that there are none, may I have a motion to approve this agenda as presented?
So moved.
Is there a second?
Second.
Moved and seconded. All in favor to approve this agenda, say aye.
Aye.
That motion passes 5-0. We are going to start with an action item. It will be for the election of governing board officers. I'm going to ask, we'll start with we'll do both different leadership roles, the president and vice president, and I'm going to ask if there's anyone who would like to declare themselves as not interested for the role of president before we begin. Noted. Thank you. At this time, I will collect nominations for governing board president. A person can self-select or select another person. Vice President Dr. Hartwells.
I move to nominate Julie Sanowski as the board president. And just to clarify, for those of you who have asked or assumed, I want you to know that I do have an interest in being board president. However, I have taken a new position that requires travel, so making it very difficult to commit the time that I believe that this role deserves. So, and it is my well, it is a lot of work, and I think Julie's done a wonderful job. But it is my belief that the current board president should remain for another year, and this is not a comment on any other board member, but rather I feel having a experienced and steadfast advocate of not just our district, but K through 12 public education in this role is in the best interest of our district as a whole, which is our charge as a board. So I know you've worn lots of hats, all the same hats that everyone at this dais has worn or is wearing, and then some. So I hope that you will accept and second the nomination to remain in the board president role.
Thank you, Vice President Hartwells, and I do accept that nomination and second it. Are there any other nominations at this time?
Yes,
Board Member Carney?
Yes, I move to nominate Karen Warner to the position of president for the Scottsdale Unified Governing Board for 2023.
And I do accept and second, and it would really be an honor to bring some new perspective and some new energy to the board.
Okay, thank you. And I would just like to add that in my experience as the governing board president, I have learned a lot. I feel like I work well with others. I'm a good listener. I am empathetic. I ask good questions. I am willing to assume the extra duties and responsibility to serve as a school board president. And lastly, I recognize that we all have a lot of work, challenging work ahead of us. And I am willing to support our governing board to do that work. At this time, we will vote in the order of nominations, and that would be for Julie Sanowski for president. All in favor, say aye.
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 Opposed?
Nay.
That motion passes 3-2. I will continue in the role as president. I will now take nominations for a role for vice president. And I would like to continue the leadership team that we have had in place and nominate my colleague, Vice President Dr. Hart Wells. I feel that she has done an excellent job being ready to go when needed if I have not been available for particular roles, and I hope she accepts this nomination.
I will accept the nomination. And I appreciate your support.
Are there any other nominations for Vice President at this time? Board Member Carney.
I'd like to nominate Karen Warner for the position of Vice President and Deputy.
All right. Okay, at this time, we will vote for the role of Vice President.
Procedurally, you did not take seconds on those nominations, so you should take a second before you vote.
Okay. The first nomination I made was for Vice President Dr. Hart Wells to continue in that role, and I would like to second, no, I can't second my own.
I accept and I second.
Thank you. Okay, she accepted and
Apologies,
seconds.
Mont.
And all in favor to vote for Vice President Dr. Hart Wells, say aye. Aye.
Aye.
All opposed? No.
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 The motion is denied, and all in favor for,
You need a second.
I need a second. The nomination was for Karen Warner to be Vice President. Is there a second?
She accepted it. I seconded when I.
Okay.
Thank you.
All in favor for Ms. Werner as Vice President, say aye.
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 And opposed? No? No. That motion passes 3-2 with Ms. Werner as the Vice President. At this time, we're going to do a little switching, I believe.
I don't know that we need to switch at this
Okay,
time because you're
okay.
still
All right,
meeting.
all right.
So we'll reorganize at
So we
the-
will not switch at this time. Okay, and now we will move on to Agenda Item 4, Superintendent's Comments. Dr. Menzel.
Oh, good evening, President Sanowski, Vice President Werner, and members of the Governing Board, and Happy New Year to the new SUSD Governing Board. A lot of things are taking place, but my report will be brief this evening. The first thing that I want to call your attention to is that on Thursday, January 12th, we will be hosting the 23rd Annual Martin Luther King Youth Voices Gathering at Saguaro High School. Many of you have had a chance to participate before. This is held in conjunction with the Community Celebrating Diversity MLK Junior event that is now in its 29th year, I believe. The keynote speaker will be the Reverend Dr. Benjamin Chavez, and all board members are encouraged to attend if your schedule permits. Our student performances are memorable, the student stories are compelling, and then, of course, we get the benefit of hearing the person who will be the keynote for the CCD dinner that evening, and so we'll get a preview of his comments at that time. Secondly, I'd like to give a shout out to Michelle Irvin, our art instructors in the Coronado Learning community, as well as the students, and most importantly to the students, for our new visual art display. So as you know, this year we've been rotating through the learning communities, and the art behind the board tonight is representative of work in the Coronado Learning community. So thanks to everyone who has contributed their talent to making sure that we remain student-focused in all that we do here in Scottsdale. Number 3 is another point of pride and celebration that over the break, we learned that 3 more of our schools qualified for results-based funding. That will bring in $600,000 more than we had previously. Those 3 schools are Mountainside Middle School, Tonalea, and Yavapai. So congratulations to the staff and leaders of these schools, 2 of which are Title I schools, and so we're very proud of the work in all 3 of those buildings. And finally, each year the governing board members are assigned a learning community to represent. Now, as a governing board member, you represent the entire school district, but conveniently, we have 5 board members and 5 learning communities, and so this provides an additional opportunity to get to learn and know the schools and the people within those communities. And so for this year, and when you serve 4 years, you have a chance to represent 4 of the 5. If you run for a second term, then you can get all 5. This year, the assignments are in Arcadia. It will be Amy Carney. Chaparral and Scottsdale Online will be Dr. Hart Wells. Coronado will be Karen Werner. Desert Mountain will be Julie Sanowski, and Saguaro will be Zach Lindsay. And so I know that the principals all look forward to those conversations, and it's been my experience that oftentimes parents will reach out to the board designee from those community members just so that you have an easy way to have input into board conversations as well as sharing concerns about what's happening in those learning communities. So thank you all for being willing to serve and represent those communities in addition to the full board responsibility. With that, I'll conclude my remarks for this evening.
Thank you, Dr. Menzel. We will move on to Agenda Item 5, Information Discussion Items, which includes our annual open meeting law and public records law training with our counsel, Jennifer McLennan.
Thank you, Madam President, members of the governing board. Give me a moment and I will start the slideshow. So congratulations to you both on joining the Scottsdale Unified School District Governing Board. I have had an opportunity to provide training to the two newest governing board members on a small group basis. But the purpose of tonight's open meeting law training is just to give you all a refresher, broad overview again of your requirements as public officers under that statute. And then this year I also wanted to touch on public records law and the requirements under that statute. So that's the purpose of tonight's presentation. Again, we're going to look at some frequently encountered situations, discuss the requirements of public records law and the requirements of open meeting law. I have trained on both topics for up to an hour each at a time. So again, this is a high-level overview. Dr. Menzel would never permit me to stand up here for 2 hours on your first board meeting. So, and I guess one important note for the review of this topic is that the open meeting law doesn't stand alone. It interfaces with many different areas of the district, some of which are not inherently the first thing that you would think of. For instance, student discipline hearings and employment law hearings interface with the open meeting law. We have certain committees that are required under state law to be operated under the open meeting law. The board governance, obviously, is required under state law to be in compliance. Open meeting law and the public records law are connected. In fact, one of the reasons that you can have an executive session under the open meeting law is if you are reviewing confidential records, which is somewhat defined by public records law. The election law, overrides and bonds, that intersects with this law, as well as what I would call common law privileges, or things that don't arise out of statute. For instance, the attorney-client privileged or the review of medical information. Those would be two examples that might be applicable in the school district setting. We're going to breeze through public records first. The general policy of the state of Arizona is in ARS 39-121, and it says that public records or other matters in the custody of any officer shall be open to inspection by any person at all times during office hours. So that's the underlying basis of what is often known in other states as the Sunshine Law. There are exceptions to the public records law. One of these, the main exception that could apply to you all as public officers, is records that are in your possession but that solely relate to a personal matter and that don't have any relation to your official duties. Emails is the most obvious example. So there's a case that comes to us out of Pinal County. It's Griffiths is the plaintiff's name, and that public officer had his email records requested under a public records request and refused to turn over emails that were simply personal in nature, that were about his family, that were about lunch appointments, what all. And the court at that point in time determined that those records, even though they were kept on a public system, were not public records. Although there's a presumption in favor of the public interest and their right to know, that can be outweighed through what the law calls a balancing test by a legitimate government concern about privacy and the best interest of the state. And Scottsdale Unified was the named plaintiff in a lawsuit that I participated many moons ago. Ira King was your HR representative, for those of you in the audience who remember Dr. King. But he testified that in Scottsdale, teachers' dates of birth were very personal and very private. The media wanted those dates of birth because they were taking lists of employees, running dates of birth, and figuring out who might have criminal background records. And so the school districts in the state banded together, and it was found that the teachers' dates of birth outweighed the public's right to know. So that's one example. There's over 300 laws in Arizona that protect certain portions of records as confidential. One important one for a school district is teacher evaluations, 15537. Says that you can't have a teacher evaluation, even if you're a board member, unless there's a legitimate reason to know and have that information. So for instance, in your roles as board members, God forbid, you might have to consider the termination of a teacher, and those evaluations would be relevant in that proceeding, and you would be entitled to them. But otherwise, those are covered and protected by state law. Medical data is another example. Student records are protected under the Family Education Rights and Privacy Act. Executive session minutes is a very good example, combines with the open meeting law. Those records are protected and not subject to public review. And then your DCS records. If a result is cumbersome, the district has some limited ability to try to reduce the cumbersome nature of records. The district's required to act promptly to provide the records, which under state law means quick to act or to do what is required. The definition of prompt is a difficult thing to measure when we're talking about the voluminous nature of the public records requests that your district receives. So we process them as fast as we can. And now I'm going to shift gears. That was what I was going to talk about with the public records law, but we're now going to talk about the open meeting law. So who's subject to the open meeting law besides a quorum of the governing board? All standing, special, or advisory committees or subcommittees or ones in which the board has appointed members are subject to the open meeting law. An advisory committee is one officially established by motion, order, or potentially by policy of the board. And an appointed would be one where they're going to be making a recommendation for a decision that you're going to be considering. So a perfect example is on tonight's agenda. You have an action item on tonight's agenda to consider the appointment of somebody to the audit committee. The audit committee has been established by board policy. So by the very nature of the fact that you all as board members will be appointing members to that committee, and that committee serves to advise you on financial issues facing the district, that committee is subject to the open meeting law. Superintendent committees are not subject to the open meeting law in general. So what happens if the board directs the superintendent to establish an advisory committee, or if the board directs who is on a committee, or if board members serve on committees? This is, I would say, somewhat of an evolving state of law in the state of Arizona. It traditionally has been thought that if you didn't have a quorum of the board on the committee, then you could still operate with one board member. But there has been a recent decision by the Attorney General's office or finding indicating that a committee with one board member was required to comply with the open meeting law. So in an abundance of caution in Scottsdale, any superintendent committee generally does not have any board member on it. What is a quorum? So you all are a 5-member board. I do have a couple school district clients who are 3-member boards, in which case a quorum is 2 people, meaning, the one board member talks to another board member and the open meeting law is already violated. You all have a little more wiggle room, but not much. A quorum of your board is 3 board members, and any type of serial communication, telephone tag type of communication, daisy chain is another word that's used. So if Jennifer speaks to, I'll pick on Dr. Benson. Jennifer speaks to Dr. Benson speaks to Alexis Wilson, then that is a communication between 3 people, and that would violate the open meeting law if we were all public officers. So the same rules would apply for you. One course of action that you can take is say, put up the stop sign and say, I can't have a discussion with you about this. I've already talked to a board member, would be one suggestion. What does it take to pass the motion? So a quorum, again, is 3 of you. It's the vote of the majority of all those present. If there are 3 members present, there is a quorum. If one abstained, there still would be a quorum unless that individual actually physically left the room, in which case a quorum would no longer exist. If you abstain from a vote, it's not a no vote. It's just a blank. Your vote is neither yay nor nay. So again, in general, if 3 of you are present, you're able to conduct the business of the board. I'm going to switch gears and talk about agendas quickly. How specific does an agenda have to be? It has to be specific enough that the public knows what you are going to be talking about. But if it is for an executive session, you don't want to defeat the purpose of an executive session. So I am lucky enough to be able to help Ms. Wagner write the agendas and answer questions that she or the cabinet may have regarding how specific an agenda item has to be. I tend to lean towards the more conservative side, be more descriptive. I have had matters, open meeting law, investigations with the Attorney General's office where clients have been found to be at fault for not being specific enough or for straying beyond the topic presented. Most recently in cases involving even the reopening of schools during COVID-19. So, we tend to be conservative about that. We want the members of the public to have full transparency and to know what you all are going to be discussing. And that's what your board docs and your intent in publicizing meetings and your actions in having those be live streamed all lean towards this board's commitment to transparency. You have very extensive personnel action items. We actually are, potentially going to try to look at combining those so that they're a little bit less voluminous for you all, and extensive voucher lists. So both of those things have to be available at least 24 hours ahead of time. And there can't be changes to the agenda sooner than 24 hours unless it's a true emergency. Let's talk a little bit about board reports. Dr. Menzel just gave a very succinct and brief and I think it was 3 points, Dr. Menzel, board report that was perfectly in line with the requirements of the open meeting law. It was a summary of current events, discussed upcoming items, discussed honors that were received over the break, but it didn't go into any item, and there was no discussion among the board about any of the topics presented. In order to be able to present on current events or have a current event summary, it has to be listed on the agenda, and you can't take any action with respect to that. And only the board member and Dr. Menzel are permitted under the open meeting law to present a current event summary. All right, we're going to switch into emails a little bit. Emails are difficult. The open meeting law includes nonverbal communication. So you can violate the open meeting law by having communication that occurs by email, that occurs under your cell phones, that occurs on any type of remote platform, that occurs via social media. All of those technologies can be a manner in which board members communicate outside of an open meeting. So generally speaking, you should refrain from sending a board member to all of the entirety of the board. The superintendent is permitted to communicate with the board by email, and you'll note, and you've already seen, I'm sure, the warnings at the bottom of the email that are standard that say, please don't forward this, please don't reply to it. There's other conventions that technologically that the district employs, such as blind copying board members so that you can't respond to all, that kind of thing. But if one board member has responded to you personally, just make sure that that's not forwarded, shared, or otherwise encountered. And regardless, one board member cannot propose a legal action by email. Just even that one email alone would be a violation of the open meeting law. Text message. In all likelihood, they are public record, your text messages, even if you're using your personal cell phone, if you're discussing board business. As counsel, I advise against sending and receiving text messages during a meeting because it just leads to that lack of transparency, and people think that you're talking among yourselves or with other individuals that are giving input to the board. So that's a difficult thing. In the age of technology, you are entitled to make statements to the press, even about your vote or what you think of an issue. A public statement on a position that you plan to take as a board member is not a violation of the open meeting law, even though you're telegraphing what you're going to be doing. But if you are commenting between a quorum of the board using any of the platforms listed here, that could be a violation. Call to the public. The governing board's entitled to make reasonable time, place, and manner decisions. The governing board and the district do all things to make sure that meetings operate in a manner in which you all can get the business of the board completed. So it's best during call to the public to allow the individuals to make the statements that they're going to make and keep them to the time, place, and manner restrictions that are set by the board president, whether that's 2 minutes in a 30-minute time period overall or 3 minutes in an hour, whatever that is. At the conclusion, if you are individually criticized as a board member, you are entitled to respond to that criticism only at the conclusion of call to the public, and the Attorney General's office interprets that as being at the end of everyone speaking, so not after the speaker finishes. But even responding to that criticism doesn't mean that it can go into a free-for-all discussion. Executive sessions. So there are limited reasons why a governing board can have a discussion that is outside the public eye. The board can do so if it's about a personnel issue, if you're reviewing confidential records. Typically, the student discipline records are reviewed, for instance, in executive session. If you are getting legal advice, if you have to instruct your attorney about certain things, contracts, cases that are pending, litigation. If you have to instruct your representatives regarding salaries, salary schedules, or compensation, which is the executive session that we have posted for this evening, is under that meet and confer exception. If you're conducting negotiations or you're buying real property. And then there's another one if you're addressing safety concerns for the district. Only those persons whose presence is reasonably necessary are permitted to attend the executive session. So for instance, if you're purchasing real estate, then in all likelihood, the business operations people of the district will be attending the executive session. For the personnel sections, the employee doesn't have if you are the individual about whom you're speaking has the right, and you all have the obligation under the open meeting law to provide notice to that person 24 hours in advance that they are going to be discussed in the public meeting in the executive session. The employee doesn't necessarily have the right to be present. Most often, it may be the best case scenario that it is legal advice that you get that the employee be allowed to attend. And even to bring in their representative. So this might come up, for instance, if you had an employee termination matter and that employee was exercising some type of due process right to appeal it, you might hold that discussion in executive session, and the employee and or the representative might be allowed to present their side in executive session. If the employee decided not to attend and you discuss an employee in executive session, they have the right to the minutes. You can't do a general discussion about any personal item regarding the district in executive session. And one good example of that is if you're going to talk about a reorganization generally, that couldn't be just globally discussed in an exec session. And again, the 24-hour notice also applies even to non-employee applicants. This mostly comes up when, for instance, you're interviewing superintendent candidates or things along that nature. Again, confidential records could include the student records, teacher evaluations, or medical records. And the legal advice exception is narrow. It's not meant to be an ability for the board to discuss something that in the presence of their lawyer. It's meant to be ability for the board to get legal advice, receive the legal advice, and ask appropriate questions regarding that. There's nuances with regard to the executive session. The only time this board could ever take action and vote in an executive session is if you are conducting a student expulsion hearing, and even in that instance, this board is conservative and you exit the executive session and you vote in the public session. That's how Scottsdale Unified operates, which is what I recommend. But you are permitted in executive session to provide direction to the attorney for the public body or to your real estate representatives in order to move the ball forward. So let's say you have a piece of litigation and there's an offer of settlement, and as a board, you could direct the attorney to go forth and try to settle the case for XYZ dollars. But in order to actually have the matter concluded, that settlement document would need to come back to the board and be approved in open session. So in general, if you do take direction and give direction, I usually advise that you have an action item after the board meeting, or after the executive session that says, we vote to direct you, the lawyer, or you, the real estate representative, to take further action as discussed in executive session. And the minutes of the executive session have to reflect the instructions that were given. Executive sessions are confidential. There is attorney-client privileged information that is given to the board as typically marked attorney-client privileged, given in status updates, memorandum, sometimes pleadings are shared with you. There is attorney advice that's given in executive session. All of that is attorney-client privileged and protected by law. And only the board as a whole may waive the attorney-client privileged, and that has to be done through a vote. And there you go. Any questions?
Colleagues, any questions? Board Member Werner? If it's green, you're on.
Green. Oh, there we
You're
go.
good.
Okay, there we go. The cord was in the way. So I do have a few questions on this.
Sure.
And would you agree that regardless of any committee, whether a board committee or superintendent committee, that ultimately results in a recommendation to the board that that committee should have been subject to open meeting law? And it's more like, do you agree or disagree?
So you're asking for some specific legal advice, and there is a matter pending that reflects that question. So what I'd like to do, if you really want more specific legal advice on that issue, would be to adjourn to executive session, which we could do under your agenda, or I'd be happy to discuss that question with you on a one-to-one basis.
Okay. So as I understand, the whole purpose of the open meeting law is to show transparency for both the decision and the decision-making process. And that's why the law does not allow for board to hide the decision-making process behind subcommittees of any kind. And the ARS is 38.431.1, and it's an advisory committee is defined as any entity, however designated, that is officially established on motion and order of a public body or by the presiding officer of the public body, and whose members have been appointed for specific purpose of making a recommendation concerning a decision to be made or considered, or a course of conduct to be taken or considered by the public body. So I'll hop to my next question, and maybe we can address the first one and when we are going into the session.
If we want to get advice on that topic, we'll have to go into executive session pursuant to a motion on that topic. So currently, we're not agendized to talk about that, but we can go ahead.
So this is in reference to slide 10.
Sure.
Yes, I would, I definitely want answers to these questions.
Yeah, and we can get you answers. It's just in terms of what format. So give me a second here. This one?
No, it's the quorum.
Okay.
Should be slide 10.
Okay.
Who is subject to open meeting law besides the quorum, and it says in the bottom, does not include a committee established by the superintendent.
Yep, or I'm sorry, I'm not following. Why don't you go ahead and ask your question, and I'll try to find the slide that you're talking about, so.
Okay, so with the superintendent committees, those are supposed to be committees considering matters that will not go up to the board for legal action. And do you agree or disagree with that?
So again, you're asking for some specific legal advice, but I can tell you that the superintendent has many committees that have the purpose of which not necessarily to present to the board, but just to run the district. So we would have to get more specific about exactly what you're asking about, and here we go.
So the subject matter of a committee that requires ultimate legal action by the board, then that committee is doing the decision-making for the board. So there are things that are happening inside of committees, and then it's coming before the board for approval or
Sure.
and so on. And that's what I'm getting to is, should those not be under open meeting law?
Okay, and so I guess what I could refer you to is the Arizona Attorney General Handbook talks specifically about, in that case, they were talking about the governor's office, being able to establish committees that are advisory committees to the superintendent's office. They may or may not inform decisions that are presented to the governing board, but the subject matter that those committees consider does not necessarily subject those committees to open meeting law.
Okay. And the series of questions that I've asked isn't it really why the Attorney General found Litchfield Superintendent's Committee on DEI was actually an advisory committee to the governing board?
That finding that was issued to the Litchfield Elementary School District in August 2021 found that the Diversity Equity Committee should have been operated under the open meeting law. And the reasons for that, under that decision, were factually based upon how that committee was set up, including that the board president asked for the committee to be established on the dais and then served on the committee. So as a response to that decision, even though that finding is not precedential law in Arizona, because it's a finding for one school district, it's not a case law, it's not in the agency handbook, but conservatively, this district removed board members from any standing superintendent committee in an abundance of caution.
Yeah, so I understand, because we're obviously having some issues with that, and so I want to make sure that we're dotting our i's and crossing our t's, and I'm 100% for transparency in our community, our families, and our teachers deserve to know exactly what's going on, and so I'm committed to transparency. And I am interested and look forward to discussing this further at a future meeting to propose a policy that the board be informed of all superintendent committees and work groups.
And it's a very pressing topic, and thank you for your questions.
Thank you.
Are there any other questions? Seeing none? Thank you, Jennifer. At this time, we will move on to our action items. And action item 6A is selection of a delegate and alternate to the Arizona School Board Association, ASBA, Delegate Assembly. And at this particular, I'll ask for nominations, and, but just kind of give everyone a heads up. What that entails is you would present issues as needed or requested by ASBA, collectively gather input from our governing board members to share with the association. You would vote as requested, representing our district and statewide ASBA decisions. Are there any questions about this particular action item? If there are none, are there any volunteers or nominations for this role, these roles? Because we're looking for a representative and an alternate. Who's interested in serving? Okay, I will continue to serve as the representative. Actually, last time I was the alternate. I will serve as the representative. Is there someone who would like to be the alternate in case I cannot be there? All right, we will not have an alternate. Why don't we leave that open for anyone having further consideration for that? I was just going to say that we need a motion. I would make a motion to nominate myself then as the delegate to the Arizona School Board Association. Is there a second to that motion?
Second.
Thank you. All in favor to approve that motion, say aye.
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 Any opposed? That motion passes 5-0. And moving on to 6B, appointment of 2 board members to serve on the Joint Advisory Education Committee. Dr. Menzel, do you want to add a little bit of information to this one?
Sure. So as a background memo points out, the city of Scottsdale created a joint education subcommittee that includes 2 representatives from city council, 2 from Scottsdale Community College, and 2 from the SUSD board. Last year was our first year of operation, and we appointed 2 volunteers at the time. We had 2 people who were interested, and we appointed those 2. My understanding is that the city of Scottsdale has council members serve for two years as part of their commitment to building some continuity, but also then having an opportunity for other people to learn. One of our 2 members is no longer on the board, and so we have one that could return for a second year, and then we have one that's open because of a board member whose term ended in December.
Thank you, Dr. Menzel. And that one that can would be myself. And I would be interested in continuing to serve in that capacity to see that work come to greater fruition. Are there other nominations for that? Please.
I'd like to self-nominate.
Okay.
Given my role as an educator and in higher education, I think I could add value to that conversation.
Excellent. Any other nominations? All right.
I would like to nominate myself as well to be a part of that. I've been involved in attending those meetings and I'm interested in serving.
Okay. So we have 2 additional nominations. Do we need to do a vote for me to continue?
What if I have questions about it, though?
Yeah.
What if I have questions? Does that come after or before? About the
Questions
committee?
About the committee? I had asked for those, but go ahead if you have questions
Oh, it's
about the
okay.
committee.
I have a quick question. I attended, I think it was the first meeting I attended last year, and then I watched it, the other one online. What are the direct outcomes that have come out of that committee?
It's meant to support and identify relationships, use of facilities, really working collaboratively between the community college system, the city of Scottsdale, and Scottsdale Unified School District, utilizing our resources and our talents.
Yeah, just to clarify, is there a result from that? Did we produce a result? from
So,
the
so
last
I
meeting?
can, I can add to that.
Yeah.
Go ahead.
So for example, one of the things that happened subsequent to conversations that we had at the table, there was an intern working for the city that talked about creating mentorship opportunities. That's one area where we're looking at how do we create those. The city's got a lot of jobs, both summer as well as year-round. There are a lot of occupational opportunities for students. And so there is a way for us to work collaboratively across the 3 entities in that area. But we also held a job fair at Coronado to provide opportunities for students to be able to get summer work, people who might not have had an opportunity or known all the different things that the city of Scottsdale offers, whether it's with Parks and Rec or other aspects of city services. So we had some of those opportunities. We also took some higher level conversations to talk about the partnership between the 3 organizations. So much of the first year was about shared learning. We've got an amazing partnership with the City of Scottsdale Police Department, working in partnership with SUSD for our school resource officers. So we talked about the value of the synergies between our organizations. We have, and it's been expressed many times by our board members that are at the table, they would like to see a more action-focused agenda. A lot of it has been informational to start with some ideas that have resulted in a few action steps, but nothing specific from that group. And while it's an open meeting, any recommendation from the joint subcommittee still has to come back to the governing boards of those 3 bodies to make a decision about something that's going to bind the organization. So there can be a natural outgrowth of a partnership that might not require action, but if we were going to have a formal mentorship program with the city of Scottsdale, that would likely be memorialized in an intergovernmental agreement. So that's sort of where we are. It's really in the early phases of how the joint committee was envisioned to function by the mayor.
Okay, thank you.
Madam President, if I understand correctly,
Your
you have
mic.
3 nominees for 2 spots. correct?
Yes, your microphone's not on. There you
We
go.
have three nominees for 2 spots, so I think that you should do the same thing that you did in taking public officers and I think that you should do the same function that you did when you, with regard to taking public officers, and just vote on each of the 3 names individually in the order received.
All right, we'll do. Yep. Right. First is motion to approve or appoint myself as a continued member on the Joint Advisory Committee on Education. Is there a second on that?
Second.
All in favor, say aye. Aye.
Aye.
Opposed?
No.
No.
Okay. Let's move on to including representatives to the Joint Advisory Committee on Education for Dr. Hartwell's. All in favor? Oh, is there a first motion? I think Dr. Hartwell's made her first, right? She nominated
It
herself.
wasn't seconded. yet,
Okay,
so.
I would like to second that. All in favor, say aye. Aye.
Aye.
And opposed? No, that motion passes 5-0. And then for Amy Carney, there is a motion. Is there a second?
I'll second.
Motion made and seconded. All in favor, say aye.
Aye.
Aye. And opposed? That motion passes 5-0. So Amy Carney and Dr. Hartwells will be our representatives to the Joint Advisory Committee on Education. Congratulations. Moving on to 6C, approval of hearing officers for student discipline and personnel matters. Dr. Menzel.
Actually, I would turn to Jennifer McLennan to talk about what is a regular approval item on our organizational meeting and the process for developing these two lists.
Thank you, Dr. Menzel. Madam President, members of the governing board. The two lists that are before you tonight, one is prepared by the Arizona Risk Retention Trust, and it's a list of vetted hearing officers to conduct student discipline matters. That's one option. And then there is also a list that's been prepared by the Arizona Department of Education with respect to individuals who are authorized to conduct personnel matters. That ADE list is referenced in the statutes that address teacher termination proceedings. The Arizona Risk Retention Trust, with respect to that hearing officer list, does require individuals to undergo training in order to serve as hearing officers.
Dr. Hartwells?
Yeah, I have a question. You said the trust prepared the hearing officer approved list that's before us. So it's really a recommendation to the board to approve?
Correct. It's a recommendation.
And when you said vetted, could you describe a little bit of what that due diligence process looks like, please?
So my understanding is that the trust, first of all, requires the individuals who are on that list to go through a training, and it's a pretty extensive training, more than a day, for instance. They have to learn how to be a hearing officer, how to write decisions. Many of the individuals on that list are former school superintendents, so I also believe that they do conduct a review of those individuals to make sure that they are appropriate to serve as hearing officers. The AD, I don't know a lot about the ADE list, although I do know my partners on it, so, they do have to be vetted. Most of those are attorneys, so.
Okay, all right. Thank you.
Board Member Carney?
Yeah, I have several questions related to this. First is, there's a lot of people on these lists that are out of Maricopa County. Are we obligated to pay for travel? Why are we approving a list full of people that are in Yuma and Flagstaff, there's Tucson, Casa Grande? Is our approval tonight approving this entire list of people?
Madam President, Ms. Carney, so it would be approving the entire list of people. In general, when the district selects a hearing officer, they will select someone local. The district, in my experience, has used the same hearing officer, who's a gentleman that I just appeared before last week for a personnel matter. I've been appearing before him for over 25 years. His name's Harold Murkow. So you have an existing relationship and a funding relationship with that individual. But in the event that Mr. Murkow isn't able to serve, by approving these lists this evening, you would speed up the process so that the district can move forward with these matters in a timely manner without having to readdress the issue. And the district administration would be responsible for making sure that any individuals selected were as looking at cost with respect to selecting those individuals.
So we would be required to pay travel if we had someone off this list come
Yes,
from another
yes.
city. And why have we gone to this method versus, how we hired Harold Murkow and Osborne Maladon? How come we aren't doing that same process this time?
So it's been my recommendation that all governing boards at the organizational meeting refer and adopt these hearing officer lists, primarily so that when you are faced with a personnel action item, for instance, that you don't hold up the matter by having to then have a board meeting to select the hearing officer before you can schedule the hearing. So that's my recommendation, is to adopt the list at the organizational meeting as a standard practice. It doesn't mean that the district's required to use any individual on this list. In fact, you could go off the list and use a different individual if that individual is board approved at a later time. So this is really just a time-saving measure, so that you're ready and prepared if you have to have one of these types of hearings.
And what if, I mean, I'm not comfortable approving a list of, with all of these people that are outside of Maricopa County. Would we be able to just approve?
You, in my opinion, if you want to limit the approval of the list, so for instance, the trust's a list of hearing officers only to those in Maricopa County tonight, that's fine if the other board members agree with that recommendation.
Okay, thank you.
Board Member Warner, did you have a
Yeah,
question?
thank you. So it's my understanding that a student goes before a hearing officer, and the hearing officer makes the final decision on the fate of that student. And if there's a staff incident, the staff has to come in front of the board, and the board has the final decision. And I find the process a little unfair, and could it be, could we have a switch to where the hearing officer can do the work, but then it has to come to the board, and the board makes the decision to decide the fate of one of our students?
So the board ultimately makes the decision regarding the students as well. The hearing, in under board policy, any expulsion is required to come to the governing board for final decision. You all aren't the finders of fact with respect to that. You employ a hearing officer, and you wouldn't have to. The governing board could hear an expulsion hearing itself. However, that would take an enormous amount of your time. They're generally held during the day. It's a difficult role for the board to be in, but you could do that if you didn't even want to use a hearing officer. But ultimately, even if it is any discipline above a 10-day suspension, it has the ability to come to the governing board.
Well, I would want to ensure that it comes in front of the board, and yes, I agree, the hearing officer should do the work and do the due diligence. And then I think that as a board, we are, invested in this community, and we should be able to make the decision for our students.
Sometimes that's the role of the parent. So sometimes the parents make the decision not to appeal a decision that's by the hearing officer, or they make a decision with the cooperation of the administration to engage in alternatives to long-term suspension, for example. So those arrangements wouldn't necessarily come to the governing board.
So I understand that. However, the hearing officer, let's say we don't have Harold, I hear that he's been very great, we have a great working relationship with him, but let's say it's some random person that comes in and they're making a decision for our students, and I wouldn't want to rely on a parent to having to appeal that decision. I really think that it should be the board that makes a decision for our students. But now, after they've done, the hearing officer's done their work.
Ms. McLennan, maybe you could point out the relevant policy. There is policy that governs this process that is not on the agenda tonight. So
That
maybe
is
this can be a
correct.
future board agenda, and so we stay in our lane. I mean, the good questions, but we tackled this last year, actually made substantial amendments to the school discipline policies.
I'd be happy to either try to answer those questions by email, or we can meet to answer those questions at a future agenda item. But in general, you're concerned that the board isn't the decision maker. The board is the decision maker with any recommendation to long-term suspend or expel ultimately, as long as the parents appeal the long-term suspension. In the case of expulsion, you're always the decision maker.
So there are many factions involved in the decisions.
Correct.
Thank you for clarifying that.
Thank you.
Of course.
So the
Board
board
Member
could
Carney.
overturn a decision made by the hearing officer?
Yes.
Yes, and this board
And
has
Okay.
recently.
Yes.
I have one more question. In my research, I'm just wondering why we're approving a list from 2017 on the Department of Education, when on the website, their hearing officer list has been updated and is from 2018. Why are we approving an older list?
The one that I checked that was in board docs was 2022. I checked it today,
It's
so,
stated 2022,
yeah,
August 11th, 2022.
yeah. So I'm not quite sure.
Okay, that was updated because the one I have,
Mine says 2017.
ours are, that's been updated since,
I don't know. The one that was posted 24 hours prior is the 2022 list.
so it changed from the Tuesday meeting then? Thank you.
the magic of Ms. Wagner. So,
All right, if there are no other questions, I make a motion to, I'm going to make a motion to approve the selection of the audit committee member list. Is there a second?
Hold on, I thought we were doing just Maricopa County. The hearing.
Oh,
Yeah.
did I say
It was-
audit? I was looking at the next thing, sorry. Yeah,
And it
hearing
was
officers.
just the Maricopa County.
Yes,
Yes.
sorry, yes.
Thank you.
Yep. Approval of hearing officers for student discipline and personnel matters. Is there a second?
Unless that with just limiting it to Maricopa County.
As presented. Seeing that there was no motion made to only approve it.
I'll make a motion and make the amendment in it. Okay, I will make a, okay.
Madam President, we have a motion on the floor, so it
Yep.
either needs to have a
Is there a
second or
second?
it dies.
No second. Okay,
I'd like to make a motion to approve the list, yeah, utilizing only hearing officers from Maricopa County.
From both lists.
Both lists, yeah.
Okay, second?
is there a second?
Second.
All in favor, say aye.
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 That motion passes 5-0. Thank you. Moving on to approval of selection of the audit committee, that is 6C. Dr. Menzel.
So as I think the governing board members all know, under policy DIE, we have an audit committee that's been established. It's a 5-member committee. Right now, there are 4 members. The policy was updated to indicate, it previously said that we had to have at least 1 governing board member on the committee. Now it's may rather than shall. And we have posted for community interest for that 5th position because we have a vacancy. We also put a little asterisk by that posting indicating that there may be a governing board member interested, in which case we wouldn't have a vacancy. So tonight, we need to determine whether or not there's a board member interested in serving on the audit committee. And if not, then we would just continue to pursue the other.
I wish to just clarify, could you confirm this, the meetings and the proceedings of the audit committee are subject to OML?
Yes, they're all
Just
subject to
confirm.
OML. Yes.
Thank you, thank you.
I would
Board
be
Member
interested-
Warner.
Yeah, I'd be interested in serving on the audit committee.
Okay, any other individuals interested? Okay, there's a motion for Board Member Warner to serve on the audit committee. Is there a second?
Second.
All in favor, say aye.
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 Passes 5-0. Congratulations. Moving on to our last action item, which is a second read and adoption of governing board policy IJL regarding library material selection and adoption.
Madam President, members of the governing board, Dr. Menzel, the governing board policy IJL regarding library materials selection and adoption was read at a first read on December 6th. It's now being presented to you as a second read and for your adoption. There were recent changes to state law in ARS 15721 and 15722 that require that after a day that passed 4 days ago, that the district have an ability to host a public review for 60 days after any library books are purchased. Parents must be notified 7 days in advance of that list of books. And so the additions to this policy would meet with those statutory requirements. In addition, there's some optional language that is listed on the agenda item that was suggested by a former board member that is up for this board's consideration.
At this time, do any governing board members have questions or comments about this? Board Member Warner.
Thank you. I find the optional language unnecessary and would not be in favor of voting for something like that.
You referencing all of it or
All
a
of the
portion
optional, all optional.
Board Member Hartwells?
Thank you. I believe we need to be called on, right?
Yes, you do.
Okay, I just want to make sure we keep formal here. My comment on the optional language is, in a bigger picture, it is oftentimes that the district, our policies are not just compliance policies, but customized with culture of the district. And I do believe that not having partisan, politically motivated, discriminatory reasons to pull books out of libraries is consistent with the culture at SUSD. So I'm supportive of the changes.
Any other comments? Okay. I actually, the language for objectionable materials that's stated, it says for reasons reasonably related to legitimate pedagogical concerns. That was a part I also support in adding. I think it's a slippery slope to be determining which textbooks are most appropriate according to our own values as individuals. I rely on the experts and parents to make those decisions for children in our schools. So I do support the language that was proposed and is in blue on our information. Board Member Carney.
Yes, I'm also not for approving this policy with the added optional language. I don't think this is necessary. No other districts are using this optional language. I say we stick to the policy as was written before the optional language was added.
Board Member Hartwells.
I think after 4 days, we probably can't state that no other districts are using what kind of language. I doubt every district in this state has gotten around to making the compliance modifications, which we do need to make. But I'm not sure we should make that kind of
Okay, sorry.
kickback, sure.
That was
Just to-
specifically to our district. This language is specifically written for our district. And so I am not in favor of approving this with this optional language. Thank you.
Any other questions or comments? Board Member Lindsay.
Jennifer, do you think the optional language is necessary or?
Madam President, Mr. Lindsay, the optional language is more specific about what the superintendent's direction shall be with respect to removing or not removing. It is not legally necessary.
Board Member Hartwells.
Again, the culture at the district, there are many policies that are customized for the district beyond what the state legislature says you have to do. If all we were going to do is a bunch of compliance policies, we really wouldn't need to be doing policies, right? That would be letting the state legislature run the district, which I don't believe any of us ran our campaigns because that was what we wanted to happen. Again, just pointing out that while legally necessary, a lot of the customization of our policies are not because they were legally required, but because that's the tone we wanted to set for our community and for our students and for our teachers, staff, so.
Thank you. Board Member Werner.
So I actually disagree that that language supports the culture of our community. And there are 2 districts specifically that are not utilizing the language, and I've reviewed that as Chandler and Peoria. So I think that it's, again, unnecessary.
Jennifer, can you please read the optional material for those that are not able to see this and what we're referencing?
Oh, I'm sorry. We may have. That would have been helpful at the beginning. Sorry, President Snasky. Actually, it's not there. Oh, there it is. Optional languages in the
Yep.
middle, right there.
And there's one up there,
Correct.
objectionable materials too, under that
Right.
list. There you go. Objectionable materials, it says, the optional language is for reasons reasonably related to legitimate pedagogical concerns, as I had stated before. And then down at the bottom, I will read that too. Books or other material from the library may not be removed due to the board's or district's disapproval of the political ideas or social perspectives discussed within them, nor may the board or district determine the content of the district's libraries in a narrowly partisan or politically motivated manner or discriminatory purposes. That's the language we're all considering here this evening. Dr. Hartwells.
So, Ms. McLennan, it does seem that legally you can't make discriminatory decisions, correct?
Correct. Legally, you cannot make discriminatory decisions.
So this is some legal weight here. And most certainly, we wouldn't want a culture or promote a culture where our libraries are subject to politically motivated efforts to purge reading material. I don't think anyone's hoping that that will happen here.
Well, I appreciate all the conversation that's taken place, and at this time, I'm going to make a motion to approve this agenda item as it's presented with the included optional language as part of our policy. Is there a second on that?
Second.
All in favor, say aye. Aye.
Aye.
Opposed?
No?
No.
The motion passes 3-2. And we are going to move on at this point into our executive session. So the governing board may recess into executive session pursuant to ARS 38-43103A5 for the purpose of discussions or consultations with designated representatives of the public body in order to consider its positions and instruct its representatives regarding negotiations with employee organizations regarding the parameters of interest-based negotiations. At this time, I would like to make a motion to recess this special meeting and move into executive session. I ask for a second on that request.
Second.
All in favor, say aye.
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 The motion passes 5-0. We will clear the room and move into executive session.
And just here, you're welcome to remain outside until, but there is no other action by the board on the agenda for the remainder of the evening.
Okay. The time is 8:22 PM on January 5th. At this time, we reconvene into our special meeting. I ask for a motion to adjourn this special meeting of the Scottsdale Unified School District Governing Board.
So moved?
Is there a second?
Second.
All in favor to adjourn, say aye.
Aye.
The meeting is adjourned at 8:22 PM.